Welcome to Legal Studies, and today we're going to be learning about the key personnel in a criminal trial, and in particular we're going to focus on the parties and the legal practitioners. So where are we in the study design? Well, in the last video you will have looked at the judge and the jury, and today we're going to look at what the parties do and what the legal practitioners do. So let's start with the parties. There are two parties to any criminal trial, and so the parties are basically the two sides. So we've got the prosecution, who's the party bringing the case to court, and we've got the accused person, who's the party who has been charged with the offence. These are the two sides of the case. We call them the parties. And their main responsibility is that they have complete control over how they're going to choose to run the case. So there's sort of two levels to that. First, they've got control over the sorts of strategies they're going to adopt. They might have control, or they do have control over the decision to call witnesses. So who are they going to call and who are they going to choose not to call? What sorts of legal arguments are you going to make? Are you going to say, I didn't do it? Or are you going to say, well, I did do it, but it was self-defense? That's the sort of decision you would be making as an accused person. Whether or not to plead guilty or not guilty would be a decision that the accused makes, as well as the decision about whether to hire a lawyer or not hire a lawyer. And then on the other side, we've also got their responsibilities in terms of how they run the case in the courtroom. So their job is to give the opening address, to explain to the court what the issue is about. They question witnesses, they give the closing address, they take part in choosing the jury or challenging jury members. So they're running the processes or running their part of the processes in court as well. That's their responsibility. Now, there's a lot of overlap here with what the lawyers are doing, with what the legal practitioners are doing, and we're going to have a look at that in just a second. Now, just the same as last time, you need to be able to discuss this topic, which means you need to know some strengths and weaknesses. So a strength of the responsibilities of the parties is it's one of the ways in which we achieve equality in our legal system. Every legal case in Australia, we give both parties the same opportunity to call witnesses, to put their case forward, to cross-examine people. We give them all the same sorts of opportunities as anyone else in any case. So we're achieving equality in that sense. On the other hand, you might say that some of those things are going to be really, really hard to do unless you've got the help of a lawyer. And if you can't afford a lawyer, you may not be as good at questioning witnesses, or you might not make as good a quality decision about whether to plead guilty or which witnesses to call. So you're going to be at a disadvantage, and that might not achieve fairness in our legal system. All right, now let's move on to what the legal practitioners do. So in a criminal trial, the legal practitioner is your lawyer. And in every criminal trial, all of our prosecutors, so one of the parties is the prosecution, and they are always legal practitioners. The accused person, on the other hand, is usually not a legal practitioner. And so they will usually need to hire a lawyer, to hire a legal practitioner to help them run their case. And that's where this stuff comes in from our previous slide. These are the things in this box here that a lawyer is really going to help you do. It's usually the lawyer who's going to present the opening address. It's usually the lawyer who's going to help you choose the jury. It's usually the lawyer who's going to do the closing address and things like that. So that's one of the main responsibilities of legal practitioners, is to help the parties with the preparation and presenting of evidence in court. And then these next two are further responsibilities that the legal practitioners have. And first of all, this one here, the legal practitioners have a duty to act in the best interests of their client. So they have to help you present whatever your case is in the best possible way that they can. They have to give you advice about what steps they think you should take. And that's sort of their main job. On the other hand, they have to balance that up with the fact that they've actually got a duty to the court as well. So lawyers have a duty to you as a client, but they also have a duty to the court. They can't mislead the court. They can't ever lie to the court. And they have a duty to assist the court generally. So what that means is, the lawyers have to make sure things are, all the things are filed with the court, that the court gets all the paperwork they need, that things are happening quickly and efficiently, so they're not wasting time and things like that. And if these two duties are in conflict, if the duty to the court and the duty to the client is ever in conflict, they actually have to owe their duty to the court first and foremost. So, for example, if the client says to you that they want you to lie and say, "Oh, this happened," when they've told you it didn't happen, you're not allowed to do that. You can't lie to the court, and so your duty to the court always comes first. And again, we need to consider some strengths and weaknesses of the responsibilities of our legal practitioners. Now, on the one hand, they can help us to achieve fairness in our legal system, because people who don't know, an accused person who doesn't have much legal education, they're going to be pretty disadvantaged. So, if they're able to hire a lawyer, that lawyer can help represent them and help try and sort of balance the playing field and negate some of that disadvantage that they might experience because of their lack of education. On the other hand, we know that not everyone can afford a lawyer. And so if you're not able to afford a lawyer, that can reduce access to justice. It can also reduce your ability to get a fair trial because, again, you might be disadvantaged compared to the prosecution, who are always lawyers. And that's it for our responsibilities of our parties and our legal practitioners.